I'm going to go back and just know of a variety of questions we've gotten asked over the time. So someone gets hurt on the job and the workers' comp insurance carrier says, you got to go get drug tested. Is that common? Is that standard?
It is standard practice. The law does allow your employer to have you drug tested after a work injury. And the reason for that is the employer and the insurance company especially is hoping that you test positive for either drugs or alcohol or prescription drugs in the hopes that they can deny your claim, because the law was changed back in 2012 that if you test positive for either alcohol or marijuana or any other illicit drugs or prescription drug that maybe you're not prescribed, then they can deny your claim, and you then have the burden of proving you were not intoxicated at the time that you got hurt, which can be a difficult thing to prove sometimes. We've been able to do it in several cases in several different ways. But yes, they can have you drug tested. You do have to submit to that. Refusing to submit to a drug test is a way for them to deny your claim. And I know nobody wants to go do that, especially if you've been hurt. You know, you're more focused on trying to get treatment. But unfortunately, in Mississippi, you do have to go get drug tested after you have a work injury.
Gotcha. And take us through, so someone gets, hurt on the job, and let's say it's severe enough and they get taken to an emergency room. Because as you talked about, there's lots of doctor referrals, the chain of selection. So you go to the emergency room. Is that considered your choice, or how does that impact an injured worker and their ability to see other doctors?
Right. Yeah, a lot of times you'll have a significant injury that requires maybe a trip in the ambulance to an ER. That is not going to be considered your choice of physician in Mississippi. It's emergent care. You need it because there was an injury that needed to be addressed quickly. After that, though, you have a choice. All right, you can accept treatment that's going to be offered by your employer, or you have the right to select your own physician in the state of Mississippi, which is really different from a lot of our sister states here in the South, where you don't have as much choice over who your doctor is, who you see to treat you for this injury. Now, the one big issue that we run into in Mississippi with a lot of our clients is if they call us late. If you call us well after an injury has occurred and things have been going, and then you run into a problem, it's harder for me to come in and fix some of those problems. And one of those is if you treat with a doctor for 6 months or longer, or have surgery with that doctor, then even though you may not have selected that doctor, under law, it automatically becomes your choice of physician. So let's say I get hurt at work, and Richard says, you got to go see, Dr. So-and-so, and I treat with him and either have surgery or treat with him for 6 months. Well, even though I didn't pick him, Richard did, that becomes my choice. And then it becomes harder to switch or potentially see another physician at some point on down the road. So there are some pitfalls in comp, and that's why I think it's better to have an attorney than not, and probably better to get one sooner than later.
Yeah, I think you hit the point right there. Just like our auto practice on a workers' comp practice, it always is better to call early. I know Richard has done a commercial in the past for an auto case that says the first 10 days are the most important, and they truly are, because you may need photos of gouge marks in the road, photos of property damage, things of that nature. And I know workers' comp's the same way. You want to make sure you get in that chain of referral so that you don't get stuck maybe on a uber conservative, right, doctor path versus one that's more, moderate or middle of the road that calls it the way they see it.
Yes, real quick, and I understand he just explained it pretty much, but anytime you have a workman's comp claim with a personal injury claim, you receive monies on the from the workman's comp because you need surgery or you have immediate medical attention, you have to pay that money back once you get you settle your personal injury case, if there's any monies paid out on the workman's comp side. Plus, I want to know from him, typically what you have to do is when you have a workman's comp claim, and let me get this right, if you owe any child support, if you owe any taxes, if you owe any monies to the government, they take all those monies out of any type of claim before you are paid out. And also on a workman's comp claim, you cannot. They keep a record of it so that you cannot, if you have a claim later, that there could be a question that both claims or both the injury to the same area, you cannot get paid twice.
Right.
Is that correct?
Bob, you bring up a lot of great points and questions. So the first that I'd like to answer that you've brought up is the liens, the other liens that could be applicable to a workers' comp case, and you're absolutely correct. If you have a lien on file with either child support here in Mississippi or any other state, there's a federal program that helps identify those individuals who have back child support and pending claims, such as workers' comp claims in states, and they notify those government entities. Here in Mississippi, it's the Mississippi Workers' Comp Commission. And yes, you do have to pay back child support out of the proceeds of a settlement or award that you may be granted by a judge. And we deal with DHS all the time. There are situations where maybe a person's got a really large lien and you've got to negotiate just paying a portion of that out of the proceeds of your settlement. So yes, that is something that we have to deal with quite a bit. Looks like the music's coming in.
It is. So if you want to hold on, Bob, we're going to go through this break, and then we'll come back and answer those wonderful questions you asked, because those are so important as they apply to workers' comp and how you actually can receive money.
Thanks, Bob. So we talked about the lien issue. One of the other questions that you brought up was they keep a record of your injuries, and that would preclude you from potentially recovering if you have a separate injury, maybe to that same body part later on. And the answer there is you can have a pre-existing condition, as a lot of people do, or a prior injury to maybe your low back or arm, what have you, and then have a re-injury, a separate incident at a later date, and that is still a workers' comp case. That's still a workers' comp claim. They can't deny your claim simply because you've injured that body part before. Now, the issue becomes, did this new injury either aggravate or exacerbate your underlying condition? That separate claim that happened at a later date, they'd only be on the hook for anything that made that injury worse, right? They don't have to pay for, you had a herniated disc before, you hurt your back again, it's the same herniated disc. You know, that's not really a new injury. That's just maybe a continuation of the same. But if that injury was made worse by this new incident, then yes, even because you had that prior injury, it is a workers' comp claim that is covered under the law.
Is there any, we've been asked this before, is there any medical treatment that's not covered by workers' comp, say acupuncture or something's experimental treatment or a chiropractor?
Right. We do have a workers' comp fee schedule that's set by the commission that does really, it's very insurance heavy talk, but it's essentially a list of what they will pay and what they won't pay for. Chiropractic visits under comp are limited to, I think, 12 visits. I've had folks get Botox injections for migraines, but those are only covered under a limited basis. So there are certain things that aren't necessarily covered. However, by and large, most everything is covered so long as your doctor says it's reasonable, it's necessary, and it's related to your work injury.
Gotcha. You and Michael in our office, you're wrestling.
I would take him down.
You would. I would put my money on you. But you're wrestling, and one of you gets hurt. Are you covered under workers' comp?
Right. It's a great question, and it depends. I'll give you the lawyerly answer. It depends. If the altercation, if the roughhousing that occurs is related to work, such as I'm mad that Michael left the coffee pot on and burned up the coffee, and we argue about that, then we get into a fight. That is covered. Now, the aggressor, the person that physically starts the altercation, typically not covered. If you start the fight, you're not covered. The person who maybe had the fight started against them would be covered. Another wrinkle in this is if Michael and I have a personal disagreement wholly unrelated to work that maybe started outside of work and spilled over into work, not covered under the workers' comp law. So really fact intensive and fact-based as to whether or not two employees fighting can be covered. But the answer is that it can. It certainly can.
And I would assume a case like that is going to be so evidence dependent on having coworkers that kind
That's
of
right.
witnessed or knew facts or knew all the underlying.
I have that very case going on right now, and it all depends on who started the fight. There's conflicting testimony from my client and the other person. We're trying to track down witnesses because that is what controls whether or not my client can recover.
Very good. And then another question says, can you make a workers' comp claim for a mental/emotional injury with no associated physical injury?
They're just burning us up with great questions this morning, and the answer to that question is yes. We do have a workers' comp coverage for a purely mental injury. It can still be an injury even if there's no physical act that took place. And an example of that would be if you're on the job, let's say you're a security guard at a hospital or something like that, and an assailant comes in and murders somebody in front of you while you're on the job. You weren't physically harmed as a result of that, but as a result of witnessing that brutal incident, you suffer a mental trauma that is covered under Mississippi Workers' Comp. Now one aspect to talk about that is that the standard of proof is higher in a case where there's no physical harm. Where it's just mental, the burden is a little bit higher. You have to prove by clear and convincing evidence that it's a work-related injury. So that's a little bit different than the standard injury that takes place that does include physical harm. So.
And I would assume in workers' comp, just as in an automobile accident claim, a lot of it is dependent on what are the findings of the medical doctor you're going to, or in a mental claim, you're going to have to go to a licensed, psychologist or psychiatrist, somebody of
right.
that nature.
Yeah, workers' comp's based, you have to have medical proof, medical evidence that your injury is work-related and that your treatment is necessary to treat that work-related injury. Without that, you do not have a claim for the most part. You've got to have medical proof, got to have medical evidence, and so what's in the doctor's records is vital to proving your claim.
This text in, it says, my son was hit on Mississippi College campus. He was in the crosswalk. I expect the other driver's insurance to pay for his medical bills. However, I'm concerned about the long-term medical issues that may arise later that stem from this accident. How do you suggest we proceed? That's a great question, and that's what we do day in and day out are these types. And that's where you have to have good, hard conversations with the medical professionals. Plain and simple, you have to be able to say what the injury is and ask that doctor what the long-term, consequences may be. Because at the end of the day, if that other driver's insurance company says, hey, we're going to offer you X number of dollars, and your son chooses to take it, assuming he's going to be 18 or older, the case is over with. This is not this is a big difference between
right.
a car wreck case and a workers' comp case, is that you can't settle the car wreck case and keep medicals open. That's not a
right.
possibility. They want a release from your son so that case is over and done with. So your son has to be a good historian to that doctor. If he suffered a head injury, is he having headaches? Or do you all notice as parents that his speech is, slurred now or things like that, or you see mood changes? Y'all have to let the doctor know that so that they can be cognizant of those facts to determine what, if any, future medical treatment he will need. I will tell you from personal experience, we're fortunate in that the thousands or hundreds of thousands of people we've represented, 99.9% of people completely recover from their injuries.
Mm-hmm.
So fortunately, the way God made the human body, we're able to heal we get healed through medical technology and science, and people don't have, issues in the future. But if it was such a significant injury, you definitely need to make sure he and you are communicating to the doctors anything that you're seeing that is different now than before the accident happened.
That's absolutely right. And, some of the personal injury claims that I've handled over the years that were larger in nature, it was because of the cost of future medical care that was going to be necessary to, treat that permanent injury. And that's something you've got to get from the doctor. Just like you would in a workers' comp case, you've got to have a doctor opine that, because of this injury, they're going to have shoulder replacement surgery in the next 5 to 10 years. You have to get that opinion down, and then try to use that in a car wreck case or a personal injury matter to negotiate the best possible resolution that you can. And not unlike in a workers' comp case when